Okay, let me start by just reviewing a little bit of what we did the other day, and then moving forward into the case law that set some of the standards in the actual care and protection cases. So, question that was asked, and then asked earlier before class started, about the 51A, about what 51A really is. It's nothing more than the reporting statute, right? 11951A, as well as DCF regulations, talk about when a child is, when there is reasonable cause to believe, remember that's the standard, that a child is being abused or neglected. Both mandated reporters, and that was a huge class of people that included law enforcement, educators, court personnel, clergy. That group of people are the mandated reporters. They are mandated to report to DCF instances of abuse and neglect when in their professional capacity they have reason to believe a child or children are being abused or neglected. So both mandated and non-mandated reporters, anyone can also report. But that's all 51A is. It's just the reporting statute. 51A doesn't always trigger DCF going to court and getting a court order for custody of children. It does in certain instances, and we'll get to that. But as I mentioned the other day, you can have the department, which under its dual obligation, right, to strengthen and encourage family life and at the same time protect children, offers services to families so that they can help exactly do that, strengthen, help the families with the children that they have. So that's the agency sort of doings. And the agency can be working with a family for, even for years without going to court to get custody orders, without going to court to remove children from the home. So again, 51A is nothing more than the reporting statute. But once someone does report, DCF now has a duty to do something. Okay? Now they can immediately, we talked about that the other day, they can immediately screen out a report because, for example, it might have nothing to do with its own obligations. So remember, it's abuse and neglect by a caretaker. And a caretaker can be a parent. It could also be someone who's caring for the child. And I gave you, by the way, I just sent through the email. What I did was I just chose sort of some of the key regulations that we've been talking about in class that are not necessarily covered in the statute or case laws specifically. And I made up a little file for you guys and I sent it to you. It's about 15 pages or so. Again, just specific sections, of 110 CMR. So again, the DCF screener might screen out, for example, oh no, that person's not a caretaker, that person's, the boyfriend of this student of school age. So that's not necessarily anything that falls within the goals, the number of the responsibilities of DCF. It would be district attorneys if in fact, that involves some sort of criminal action. So screen out would be the choice. Once it's screened in, then we're talking about 51B. 51B, the duties, think of 51A, the reporting statute, 51B, the duties and responsibilities of DCF once a case is screened in. And again, this side of the board, we're only talking about the agency, not about the judiciary, okay, not yet. So if and it would be screened in depending on the facts and circumstances that the screener hears as an emergency or a non-emergency. If it's screened in as an emergency, DCF workers are to get to the place where the child is within 2 hours, interim report within a day, final report by 5 days. If it's a non-emergency, obviously much longer. 2 days, they may not get to the house for a couple of days because it's not an emergency, and the report will be finalized in 15 days. But whether it's an emergency or not, then there's another choice still based on a reasonable cause standard. And the choice is whether to support that initial report of abuse or neglect or to unsupported. Unsupport if there's a lack of reasonable cause, support if there's reasonable cause. And so that's the 51B workers' investigation and report. If it is supported, then there's an assessment worker or workers assigned to the case, and they do a longer looking at the family that takes up to 45 days. They complete their assessment plan, and after that, within 10 days after that, there's a service plan for the entire family that includes, and some of this stuff is in the regulation file that I sent out to you. It includes, tasks the family members have to do, so they could be in compliance, and so that DCF will ultimately, close the file or not. Service plans usually are updated after about 6 months, depending what's going on with the family, depending on the services that are provided, depending on where the children are and so forth. So it isn't just one service plan and that's it. It's continually looked at and updated. So let me just back up now to the emergency, and now we'll get to some of the case law that you have to read for today. Any questions so far? So what's the burden on the department, Ash, if children are removed from the home on an emergency basis?
Reasonable cause?
You're saying, okay.
Clear
Are you
answering?
I'm saying, what does the department have to do if they take the children? But I think you were trying to answer on what basis. What basis do they remove children from the home?
Well,
you can answer either question. I was jumping ahead to they already took them. If you want to talk about why they should take them, on what basis they should take them, go ahead.
Well, it used to be the fair preponderance of
No. You're getting into the hearings. So social workers are at the house.
Okay.
They've been called in because the screener screened it in as emergency. Okay. So at the house, what decisions do they have to make? Lester?
Is there immediate danger of neglect or abuse to the child?
If the children are not removed.
Right.
Okay. All right. So once they make that decision, because you were jumping way ahead, Ash.
Okay. You're talking about substantial risk of imminent or serious injury.
Exactly, and that's what Lester's saying too. All right. So once the children are removed, all right. Now the parents normally have custody, right? So what does the state have to do next? You had it, but you were jumping way ahead to like the next hearing. What do they have to do first? I took little, Emma and Joe from, your house.
Okay.
You're the parent, all right? I placed them in, foster care overnight. What do I have to do other than that?
You give them a right to counsel.
Well, before that, before you can have a right to counsel. Patricia?
Due process?
Well, yeah, you're giving me all the arguments, and I've taken these kids from the house, and today's Tuesday. I took them last night.
Notice.
Notice of what, Jadida?
You have to file a report, and then you have to get,
I have to file what?
you have to file a care and protection order under section 24, and then you
Wait, you're right except for the word order. I have to file what?
okay.
How do court
A care and
actions
protection
start?
report.
Any kind of
Petition.
case, a petition, a complaint. So I have to initiate something in the courthouse before you can have counsel, before notice goes out, before you can make due process arguments. Because I've taken these kids on an emergency basis, that only lasts so long. So I now have to, in order to get the order, I've got to file the petition first that starts the case off. Again, you now have a docket number. Ultimately, notice goes out, but it's the next business day, whether it was Friday night and Monday morning, if it was Monday night, it's Tuesday morning. I'm in court with my petition. So overnight, the social worker has a lot to do, right? DCF has to not only place the children temporarily somewhere, has to prepare the petition. The petition is pretty much, what am I saying, a form. Okay, but the worker also has to draw up his or her own affidavit about the specific circumstances as well. Again, run to court, get that filed in the clerk's office, put it on the list to be heard that day, right? And when I say to be heard, you've done two things that day. You've not only filed your petition, but you're getting a hearing right away. Why are you getting a hearing right away, Jeremiah?
Well, you need an emergency hearing because you took the kids
Right.
without technically allowing the parents the time to put up a front type thing. So in the best interest of parents, basically, you need the emergency hearing so that they can get their due process in and get their say, so to speak.
Well,
And also to justify you
are
having
parents
kids.
at this hearing?
Oh, no, you're right. No,
Okay.
you need the emergency hearing so the judge backs up your decision to take the kids out.
Yeah, this is pretty much ex parte. Social worker, DCF attorney might be in the courtroom. And because it's in the nature of an emergency, what is the standard?
Reasonable cause.
Reasonable cause. And where do you see that language again?
In the cases.
Not in the cases, actually.
In the 72-hour hearing.
No,
Statutes.
where do you see the standard?
Statutes, isn't it?
It's in the statute. So 11924 itself which is the beginning of a care and protection case. Third paragraph down, if the court is satisfied after the petitioner testifies under oath, again, that's the social worker with her affidavit, that there is reasonable cause to believe. Okay. So the standard for the emergency hearing is set in the statute in 24. Reasonable cause to believe a child or children is suffering from abuse or neglect, an emergency order transferring custody to the department for up to 72 hours. That's why, Lester, you would jump into the 72-hour hearings. That third paragraph contains language both about the emergency hearing and about the temporary custody hearing after the emergency hearing, and that's why it can get confusing. Okay, but all the emergency hearing is very low-level standard of proof. What is it similar to in, say, civil? Getting what? What?
Preponderance of the evidence.
No, I'm saying what kind of action in, say, a civil case is similar to the department running in to court and getting this emergency order for custody?
Like a restraining order?
Like a restraining order, temporary injunction, right? It's usually just the attorney filing and the court, and then the other parties get notice afterwards, and then you have the hearing, the more formal hearing after the getting the initial order. So that's all this emergency hearing under Section 24 is. And again, you're only having this type of hearing if the children had been taken on an emergency removal under 51 BC 3, I think was the section, okay? Now here's where it starts to get tricky. And I'm not going to take the cases in order because we need to look first at the Robert case. And I think that's the second case that I assigned.
It is.
Yeah, okay. So, once children have been taken on an emergency basis, again, the order only lasts, according to the statute, for 72 hours. By the way, the first time, which this is the first time the department is in court, the judge is then going to be, the Judita or San Jose notice before, going to be appointed, counsel for the parents, counsel for the children, the appointed investigator pursuant to the statute as well. And the case is then continued for the 72-hour hearing. Now, where is the standard of proof for that? So we know the standard of proof for the emergency hearing is reasonable cause. Where is the standard of proof? Where do you get the authority for the standard of proof at the 72-hour hearing?
119.24.
No. Well, unfortunately, and that was the problem for years, that there was no standard of proof. If the statute mentions reasonable cause, but only for the emergency hearing. And then it says the court may issue an emergency order transferring custody of the child for up to 72 hours to the department, blah, blah, blah. But it never said what judges should do at the 72-hour hearing.
That's where they mentioned the fair preponderance of the evidence.
So where does that come from?
119.24.
No. Where do you see the words fair preponderance of the evidence in 119.24? You don't.
119.24 is reasonable cause.
For the emergency hearing.
Right.
But 119.24 also mentions that there's, that there's a 72-hour hearing.
Right.
But nowhere mentions or defines what the standard of proof is at the 72-hour hearing. So for years, what would happen is the department would get custody, emergency custody, then the case would be scheduled, and the parents had a right, and the children had a right to come back in after they got notice, and there would be a hearing on whether that emergency order of custody should continue, right? There was no standard of proof for that hearing until when? Until when?
1989.
Until 1989?
Clear and convincing evidence.
No.
Standard.
Robert.
Ash is right. I said I gave you a hint when I said we're gonna look at Robert first, before Santosky. Very tricky, isn't it? That's why I'm trying to take it step by step with you guys. So emergency, again, to repeat, emergency order only lasts for 72 hours. Statute mentions that. Statute never said, and the judge has to be convinced by, reasonable cause or beyond a reasonable doubt, or nothing like that was written initially into the statute. Until Michael Kelly decided that he was going to take the case up to the SJC. And he actually argued for an even higher standard of proof. He argued for beyond a reasonable, no, I think he was arguing for clear and convincing evidence. Yeah. So when the court engages in the rationale of why and how there should be a higher standard than than the initial reasonable cause. And I mentioned this before when I couldn't think of the name of the case. I said, remember you guys that had con law when you were reading about due process and the test the court engages in order to determine what particular standard of proof or what particular process is due. What is the test that I'm talking about, and the Robert case the SJC engages in a really, I think, clear discussion, clearer than some of the U.S. cases, on this three-part sort of balancing test. Lester?
First of all, I think it's the Eldridge case.
It is. And I had forgotten that the other day, and it was Eldridge, and I think I have the site for you guys. You don't necessarily have to look at
424 U.S. at 335.
Who just said that? Did I give it to you?
Matthews v. Eldridge, 424 U.S. at 335.
Yeah, it was a 1976 case, so it was an old case that set the standard, the facts of the case don't matter because it had to do with termination of disability benefits. But what important standard comes out of that case, Lester?
Well, balancing the interest, the private interest,
Yep.
state interest,
Yep.
and
Somebody help him with the third point.
the light.
The risk of.
Oh, you're going to say it? Okay, yeah, I know.
I'm struggling for the right word. The likelihood of error.
Yes, the risk of error. Okay, so in terms of the, what's the matter?
What's the second one?
So it's the private interest, it's the risk of error, and the government interest, balancing those. So in terms of how the SJC decided whether and to what extent the standard of proof at this next temporary custody hearing should be higher, what sort of analysis did it engage in? What is the private interest at a 72-hour hearing, Jeremiah?
Private interest. Just the parent, I mean, it's the right of the parents to have
Yeah,
kids.
and again, a lot of this, again, goes back to the earlier cases that you guys read on due process. The parental rights, in terms of custody of the child, what about the children's rights? In terms of the private interest factor of the test, Cassandra?
Wanting to remain with the family.
Remain with the family, or on the other hand,
Be removed.
yeah, be free from
Free
abuse,
from abuse or neglect.
What's the government
So
interest?
the 72 hours, did that number come out because that's what the court decided that meets the balancing test?
The number 72 hours?
Yeah.
The number 72 hours is actually in the statute
Okay.
in 11924. And the statute says that emergency order from when the case is first filed only lasts for 72 hours, at which point the parties, in particular the
So what
parents...
they're basically saying is, your right of the parents that have been taken away
Exactly.
is okay because it's only for 72 hours.
Right.
essentially.
Yeah, and it was okay to do that on an emergency basis with a very low standard, okay? But now, why should the standard be higher? Or why shouldn't it be? What's the government interest? I don't know, Joe?
Well, I mean, the government is pari, I think I'm pronouncing that right, pari parent.
Parents patriarch.
Close, and over, you guys know what I mean, overseeing that interest. You know, they have to, as the government, they have to look out for the health and safety of the children.
Exactly.
And the best interests of the children in that situation.
Exactly. And what else, Lester, does the
Well,
SJC discuss?
The temporary custody of the child is not a threat to the degree of magnitude of termination of parental rights. So
Correct.
So therefore,
It's
the
still
standard,
temporary custody.
right? The standard, just obviously, on a common sense, but also on a legal analysis, has to be higher. Because if you're going to terminate my rights...
Wait a minute, which standard has to be? I just lost you.
From reasonable cause for a temporary custody.
Okay, but what Joe just said, I think, is that the 72-hour hearing is still temporary.
Right.
I guess, why shouldn't the 72-hour hearing continue to have just the reasonable cause standard of the emergency hearing? You know, why should this change? And that's what the attorney was arguing for and got at least the mid-level standard. Why should the standard of proof be higher for the state to maintain that temporary custody standard 72 hours later?
I think it's because it's a graduated system. I mean, you get a second bite at the apple, whereas in the 72-hour hearing, now if they find, and essentially the rules are relaxed with that, if they find that there is evidence to believe that this person, the juvenile, needs to be held, then, you know, when they go for the final hearing, it's like, hey, you know, you lost at the first stage, you lost at the second stage, and then ultimately the third stage. So I think that's the ultimate reason why they did that.
Tim, you had your hand up, I think? No?
I
Somebody
don't
did
know.
over
It's
here.
just-
I did.
Oh.
No, I was actually I agree with what he just said.
What did he just say?
I mean, basically this is the last and final hearing, and when he said.
What do you mean?
The second, well, this is the 72-hour, that's the final hearing before temporary custody, right? From what it, right? Well, I know there's
Don't
trial,
use the
but I
word.
mean,
Don't
not
use the
trial.
word final
Well,
for
not
72-hour
final.
hearing. But I'm picking up on something Joe said before about, and I don't know if you use the actual language. It sets the stage.
I didn't.
All right. Remember that I said the other day that the final trial is at the quickest 15 months later. That means, yeah, the quickest. I mean, under the statute, it's supposed to be 15 months. People do get postponements. That means that all this time, if parents lose custody, parents obviously don't have their children with them for a very long time. It sets the stage. The department has custody, and we'll get to that with the Isaac and Jeremy cases too. If the department wins at this temporary custody 72-hour hearing stage, that means that the department has, quote, custody under Section 21, can control the place of abode, can control visitation, can consent to, normal parental consents that you have. Oh, can my kid, go to the school dance, whatever. So parents patria that Joe just said, DCF is acting like a parent for a long period of time, unless and until parents get custody back. So therefore, the Supreme Judicial Court held in Robert, in order to do that, it's going to be the department's burden now at this second hearing, in order to maintain temporary custody of the children, they've got to show by a preponderance of the evidence. And that's, again, our state Robert case, not the Santosky versus Kramer, which we'll get to in a second. It's proved by a preponderance of the evidence under Robert that to return the children, would put them in danger of abuse and neglect.
Didn't that clarify that it was the preponderance of the evidence, but it didn't necessarily mean that it was good evidence?
I don't know what you mean by that.
A quantity. So the quantity was more important than the quality. It had to be this one.
There was some good language in the case about
Right.
preponderance of the evidence, what the standard really means. And there was some reference to, and I don't know if I made note of it, that it's not like, anybody have the case in front of them? The court
Which
the court in Robert, in going through first the Eldridge Test,
Right.
then also defines what the standard of preponderance of the evidence is, and does talk about it being sort of the intermediate standard, higher than reasonable cause, lower than clear and convincing, a median standard that is the standard of other civil cases as well.
It says accordingly we hold today that the decision to maintain a removal from parental custody reached at a 72-hour hearing held pursuant to General Laws Chapter 119, Section 24 must meet the immediate standard of a fair preponderance of the evidence, but then I think you took out.
Yes, but what is a clear preponderance of the evidence? That's what I'm asking. If you had to tell someone what that was, say a layperson, how would you define it, John?
I would say that looking at all the evidence, a stronger case can be made for that. When you balance it out.
When you balance it, it weighs a little bit more heavily.
So-
Again, not. Go ahead.
All it needs to be is like 51%, just a little bit more than.
Mm-hmm. Yeah. That's
That there's a substantial risk if we return the child to the family of harm to the child.
Well, yeah, and you're being more specific about the children's cases. My question had to do with exactly what the preponderance of the evidence, just in general, what that standard is. I mean, you guys have read lots of civil cases, right?
Well, Cassandra's right.
Mhm.
In tort law, I think the preponderance is 51%.
Yeah, so it's a little high. You know, it's not a lot, but it's certainly more than reasonable cause, which was that very low threshold standard. Joe?
I was just going to say the same thing, and they talk about it saying that it's a more demanding standard that would lessen the risk of error.
Yeah, good. Okay. And so that's our case, the Robert case, for any temporary custody hearing. So it ultimately includes, and later on when we read the manual and some of the other cases, I've been referring to only Section 24 for the 72-hour hearing. But say if a child was not taken on an emergency basis and the department had filed a care and protection case and was looking to get temporary custody, then it would be Section 25. It's a really short section, it comes after 24. The section itself doesn't say much, but case law in Massachusetts has defined that the standard for this hearing is the same, preponderance of the evidence. So that's when I say any of the temporary custody hearings that come after emergency basis or when there's no emergency, in order for the department to get custody, they've got to show by preponderance of the evidence that maintaining the children, keeping the children in the home would subject them to a substantial risk of abuse or neglect. Now we can talk about the trial. Yes? So now we're looking at Santosky for the standard. Because just like the 72-hour hearing, our statute never had the standard of proof for the final hearing, for the trial on the merits. So U.S. Supreme Court decided in Santosky that what?
Very convincing evidence.
And why? What kind of a case was Santosky?
Termination of parental rights.
Right. So, what has Massachusetts done in following Santosky, which set the standard for a more serious case, a termination case, at clear and convincing evidence? Remember that so far we're only looking at care and protection cases as they deal with parents losing custody. So when Massachusetts decided to follow Santosky for the care and protection trials, what has it done, Joe?
Didn't it give the due process rights to the parents and the child?
Yes, but in terms of giving more rights, the same amount of rights, what is it that I'm asking here? Yeah.
That the state has to make a diligent effort to rehabilitate the family so the child can remain. It's my understanding.
Now, you're talking about the Santosky holding itself. I guess my question was, how is Massachusetts following the Santosky holding. I heard you guys just say that the Santosky holding was specifically that before a state could terminate parental rights, that the state's burden of proof was clear and convincing evidence of the parent's unfitness, right? We're not talking termination with this statute, at least yet.
Can you rephrase the question?
Okay, all right. Well, what is the standard? And it's not, and again, it's not in Section 26, but in Massachusetts, for DCF to get permanent custody at trial of a care and protection case, what's the standard of proof?
I would say it's clear and convincing.
Yeah, but okay, you're correct that it's clear and convincing. Why and in what way are we following Santosky by doing that? Because Santosky, again, was specifically for termination cases.
We're giving parents more rights.
Yes, that's all I was getting at.
We're giving parents more rights?
Absolutely. And how are we doing that? You just guessed, didn't you?
No, I'm just trying to figure out what you're asking.
By increasing the standard, right?
Yeah, making the state jump through more hoops than it has to federally. We followed Santosky, and I didn't give you the initial SJC decision. I think it was in Ray Stephen, Care and Protection of Stephen, one of the earlier cases after Santosky, that held that the standard of proof for a care and protection trial before DCF could get permanent custody was the department of the standard had the burden, and the department had to prove. And by the way, it's current, and we're going to talk about unfitness and best interest too. The department has to prove at this final trial current parental unfitness, and by clear and convincing evidence. Current parental unfitness. So that means that, when the children were first removed 15 or so months ago, has that situation changed? Maybe parent or parents have in fact gotten their act together, and maybe at the time of trial they're not unfit. And judges have to make these decisions based on clear and specific findings of fact and rulings of law. So it's not just, the decision is, custody of the department, I'm adjudicating the child or the children in need of care and protection. Yeah, that's the adjudication, but the judge will then issue a pretty lengthy written report that's based on specific findings, and then ultimately rulings of law, using language such as the department has met its standard by clear and convincing evidence, mom is currently unfit, and again referring back to specific findings upon which the judge relies to make his or her decision that the parent at the time of trial is unfit.
It just seems like the court is setting up more obstacles for the state to,
Exactly, and in line with Santosky versus Kramer, the Commonwealth of Massachusetts has afforded parents the due process rights that we've talked about, and looks first to the presumption that kids are better off with their biological family, again, unless and until the state can prove by a lot of evidence, clear and convincing evidence, that parents are unfit. I don't remember if I gave you the specific, there are a few cases that talk about, and maybe later on we deal with, I know we deal with them in the context of hypotheticals. Parents, in terms of unfitness, there's sort of, tons of factors that deal with, what unfitness is. But it relates to the parent's fitness towards a particular child or children. So you can have a parent be found unfit towards one child, but fit towards another child. And so that's when the relationship of fitness and best interest of the child come into play. One of the earliest decisions when it was DSS was one of the Little Wanderers cases. I remember the Little Wanderers home. And the SJC's a famous quote said, the fitness and best interest tests are not separate and distinct, but cognate and connected. So while on the one hand they're connected, what you have to remember though is when DCF goes to trial on just on a care and protection case just for custody, not for termination, that the focus is more on the parent, on the parent's unfitness. But yes, it still is unfitness towards the child. Whereas when the, and I'm not going to talk specifically about termination until we get to the adoption cases, but when the department does move for the most serious of all the alternatives to dispense with parent consent to adoption, then the court looks, again, the stress is more on the best interest of the child. And that's when 119, and you're not going to read 210 yet, but when 119 intersects with Chapter 210, Section 3, the adoption statute, and there's a list of 14 factors that the judges use to determine whether to terminate parental rights or not. So keep that in mind, that is the worst possible scenario in alternative. Without that, parents may have lost permanent custody, but there's still review rights. In court, under 119.26 mentions this language, review and redetermination. That's when parents and even child's counsel can go in after an adjudication and petition the court for a review and redetermination of the case based on, change of circumstances, for example. In addition, every year under Section 29B, the court holds annual reviews.
So this is just for custody?
Yes.
Not when it's terminated?
Not termination, yeah. So if it was termination, the case ends. Parents have lost parental rights. Of course, pending appeal, because a lot of those cases get appealed as well. Besides the reviews in court, when a child is in foster care, the agency also holds foster care reviews every 6 months. Yeah.
My question was, okay, let's say after this temporary custody hearing, the parents regain custody of the children. They still go through this review that we're talking about?
After the temporary custody hearing,
and
the department has not met its burden?
Right, so there's a
Are you talking about the case getting dismissed?
Yes.
Yeah.
Then the case dismissed, it's over. Unless, for whatever reason, the court holds the temporary custody hearing on the issue of, should DCF pick custody, or, for example, one of the cases that you're reading is the Manuel case, where the court can also consider parents' nomination of a temporary custodian besides DCF. So in that case, DCF doesn't have custody, but the case would still remain open based on the parents' unfitness. And the case could still proceed to trial or get dismissed at some point. Okay. And like ordinary civil or criminal cases too, in the progression of the case, if circumstances change, cases can get dismissed per agreement of the parties, per stipulation. Parent has complied with the service plan. There's no need to go to trial. Custody, returned to the parents.
And the reason why I asked about the review is because I remember reading, I don't remember which one of the statute it was, but even though, you know, the children have gone back to their parents, they want to make sure that the parents are still keeping up with, like you said, tasks, and that's why I asked.
Exactly. So the case could remain open as a CNP case.
Okay.
For example, the case could even go all the way to trial, and child could be adjudicated in need of care and protection. Under 11926, the first dispositional alternative is that they could stay with parents. So the case could still remain open as a care and protection case, but living in the home with the parents.
So the parents didn't lose custody in that case.
Right.
26.
Exactly. So that's the, you know, short of it being dismissed, that's the best alternative for a parent. And then it goes on, it names custody to another agency, custody to the department, which is the most usual, and then termination, the worst and most serious alternative under Section 26. Now, we're going to back up with Isaac and Jeremy and some of the other cases like Bruce and talk about what might happen in between, what sorts of issues come up. And we can take Isaac and Jeremy together because Isaac dealt with a decision about placement when the kid was in permanent custody, and Jeremy dealt with a similar decision when the kid was in temporary custody. So what did the judge do that was wrong, that was sort of beyond his authority to do?
He doesn't have the authority to order Department of Social Services to provide specific placement and specific staffing level for child who has been adjudicated to be in need of care and protection and committed to the department's non-temporary custody.
Yeah, for example, the child in Isaac was, I think, in McLean, and had previously been at the school, Kennedy School, correct?
Yep.
And so they were fighting over where the kid, basically where the kid should be. And what did the department want, Tricia?
I thought the department wanted him back at McLean.
Mm-hmm.
But there was an issue of money. The placement.
Right. It's always.
The judge
mm-hmm.
ordered him to be placed where there was an increase in cost, but DCF said we don't have to pay it. So the child may not necessarily receive additional services. It's like, this is what you get. But then they ended up, I thought, modifying that later because the child wasn't successful in the placement, and then he ended up getting a one-on-one.
But what was this really about?
Who had the right to decide where he went? His actual placement? Who had the authority to determine placement? And really, it's a separation of powers issue. A separation of powers? Yeah. Judiciary versus the agency. But unless the judge really had experience with that area, and that was his expertise, why would he ever decide?
One argument that was made is that there's this sort of, I call it a catch-all provision in 119 that says that the court may make any other appropriate order with reference to care and custody of the child may be conducive to his best interest. So that was the underlying argument, at least at the beginning. Gee, I have the authority to do that under this catch-all provision, and I'll agree with the family that placement should be here. But it really fell down on, and I keep going back to that definition of custody under 119.21. When DCF has custody, unless and until DCF is not following the law, not following its regulations, not following statute, not following procedure, they can do whatever they want.
So the judge can give recommendations to where he wants them to go.
Recommendations, exactly.
The department has full discretion to what the child...
No direct order. Okay, that doesn't mean that if the counsel for the family or counsel for the child feels that the department is not following its regulations, that doesn't mean that the department has this absolute discretion. Okay, if the department is acting arbitrarily and capriciously, then and it's typically a parent's counsel that will bring what are called abuse of discretion motions before the court. And then the court can order the department to do what's in accordance with the law. And only then. So as I mentioned before, probably the most popular kinds of abuse of discretion motions have to do with visitation and or placement. And it usually has to do with, placement with, family versus, family of nominations by bio parents or particular family members that they feel that the department has, overlooked or directly, contravened, or visitation, not getting the proper amount of visitation. By the way, what case that you read today sets the standard for visitation? So all along here, the minute the department gets custody from the emergency hearing up to termination, parents have not lost parental rights, so they have a right to visitation. But in what instances can the state, acting as parents patria, say, no, wait a minute, parents should not be seeing the child because blah, 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 blah. What's the standard? It's just one of the cases that you read, and it's still good law.
Custody of a minor?
Yeah.
Which one?
The custody of the minor, number 2. By the way, you notice that some of the cases read like that, or read, petition of DSS to dispense with parental consent to adoption. Well, I for many years, again, because of the privacy of not using actual names, the cases were named like that, and at some point the appeals court and the SJC started to give the fictitious names instead, which makes it so much easier to remember the cases than custody of minor number 2, and so forth. But it's that case, the custody of the minor. Number 2, decided in '89, I think. I forget what year, because that matters too. So what's the holding? What is the standard for terminating visitation?
For terminating visitation rights, a judge must make specific findings demonstrating that parental visits will harm the child or the public welfare.
Yeah, the judge has to do it. Okay, you can't. DCF, the DCF worker or DCF personnel can't say directly to the parent, we're stopping visitation. The foster mother has reported that the child is crying and having nightmares and throwing up after every visitation. So you're not going to see your kid for a while. Well, they can't just do that. In order to terminate or suspend visitation, there has to be a court order. And again, if you represent parent and the parent is saying to you, I haven't seen, I'm supposed to see the child, every 3rd week in DCF offices or whatever, and I've been calling and they're giving me the runaround. Or they directly told me, he threw up last time, so, you can't see him anymore. Then you would file a abuse of discretion motion before the court, affidavit from your client, little mini argument of yours, and tell the court that your client's been denied visitation and because the department has acted arbitrarily, capriciously, not in accordance with its regulations. So that's how the Jeremy and Isaac cases are used today, which again came about as a result of a judge actually exceeding his authority. So that's what those cases stand for. And I want to skip Sophie for a minute and go to Bruce, only because Bruce dealt with not only a nice discussion of unfitness and the correlation between, unfitness and the parent's mental state, but it also talked about the interim reports and letters that DCF submits to the court, and whether they're admissible and how and so forth. So what was the parent's problem, or according to DCF, the parent's problem in Bruce?
Mother had a mental health issue. She had paranoid delusions.
Yeah, but basically what was DCF saying? What was in the service plan? Wasn't it take your lithium? And she said no, basically. Now it makes me sick, right? Case goes to trial and she's found unfit. But based on what? Or what was wrong with the juvenile court finding her unfit?
It wasn't clear and convincing.
And why wasn't it clear and convincing? She clearly was, as Patricia said, she had mental illness. But how and to what extent did that not amount to current parental unfitness at the time of trial? John?
Because they did a good job of showing that she had the mental illness, the bipolar disorder, but they didn't really connect how that was affecting her
The
ability
child.
to
How does it affect the child? So mental, and there are many cases that also stand for that proposition, that mental illness or substance abuse or alcoholism or whatever it is that the parent has, in and of itself, doesn't constitute unfitness. There has to be a correlation between whatever the parent has and how he is connecting with the child. And it was okay. The court also talked about that, you can talk about the future. You can talk about predictions if you've got enough of the past to say, I'm afraid if this kid is placed back with this parent, based on what happened in the past, she can hurt him, that sort of thing. But here, again, there was not enough of that. And so go to the reports. So the court mentions 11921 and the reports that DCF submits. So between the when DCF gets temporary custody, between that temporary custody hearing and way down the line when there's trial, it's not like the parties never go to court. Court usually holds, status hearings, they used to be called, they're still called, every 2-3 months or so. And the court wants an update as to what's going on, what the parties are doing, what's going on with the service plan, where are the kids, visitation issues, etc. And the worker for the family will file in the form of just a letter addressed to the court. Dear Judge. That's all it is. I've been, working with the family, and last week I held a supervised visitation with Mom, who is not on her lithium, and she went to give the baby a bottle, and I continuously told her that she should be tipping the bottle up because the baby's going to get gas. That's a fact, because it's the social worker of her own knowledge, right? First-hand experience with the family, saying this is what she observed. Suppose that she says in her report, foster mother told me that when the child was returned back to the home, older child, the child woke up at night with nightmares. That's hearsay. Keep that in mind, because that may or may not get in. Again, subsequent cases in this area have held that some forms of hearsay in these reports are actually okay and come in as exceptions to normal, hearsay rules. Even though Section 21 talks about that the common law of the rules of evidence apply in these hearings. So you're going to see exceptions. One of the big exceptions has to do with not only DCF reports, but also that court-appointed investigator who does a similar thing, goes out and talks to the parties, submits a report to the court. What parties can do is ask for a redaction, for example, opinions, conclusions, multiple sources that really are not credited. So, you can move for a motion, you can file a motion in limine to redact as defense counsel, as counsel for the parent, counsel for the child. But for the most part, they're coming in. And the tricky part about at least the DCF letters, you're arriving that day for a status hearing as counsel for the parent, counsel for the child. It's not like you got that letter ahead of time. The work is coming in, sometimes not even with enough copies for everyone. So you're reading it literally, right before the case is called, or maybe you're going to ask for a second call. So you have to quickly, come up with a strategy of, if you're going to be arguing anything regarding what's in that. With the court-appointed investigator, you do get that ahead of time. DCF letters, again, and reports, not necessarily so. But that's what Bruce stands for, that proposition, and they are typically let in, allowed, used as evidence. Yeah.
With respect to the submission of those reports and admissibility of evidence in that case, would you then be able to call the investigator and subsequent as witness? You
have to, and that's the thing. With the court-appointed investigator, as well as when the case goes to hearing, DCF, social workers, they have to be present and subject to cross-examination by all the parties. So again, that's part of the rationale for, we're going to allow what's in it, but we're going to let you cross-examine counsel, or you can go through line by line and argue for redaction of certain parts. So that's the Bruce case. Trying to look. I'm jumping around just because I wanted to take them in a certain order. Zelda is actually the very last case, and it dealt with a grandparent's motion to intervene. So remember, I talked about the triangle in terms of, the family, the parent, the child, the state. Okay. In this particular case, or when arguments like this are made, you have someone, typically, a relative, or sometimes not a relative, who has, the child has bonded with, could be a foster parent, and they want in. They want in on the proceedings, after saying no. Why not?
Well, they don't have a right under the Constitution that gives
Well, let's talk about the civil rule first, before the Constitution.
the mass civil procedure.
Right, the motion to intervene, the rule that the court talks about.
Yep. The rule governing intervention of right could be accepted as a cogent standard in a care and protection proceeding.
Right. What's the basic standard for the judge to allow you to intervene under that rule?
Clear and convincing.
Of what, though? Your mind?
The parent's unfitness.
No, not necessarily. You just want to be able to be. So who are the parties in a care and protection case? So in Ray, care and protection of Paula. Okay, so I'm the child. I'm one of the parties. The department's another party. My parents are parties, right? Child, family, state. So normally grandmother's not a party, or aunt, or when I'm pulled out of the home and I'm in a foster home. Even
Unless
if I'm
they're
a
guardian?
What's that?
unless they're a guardian, is that what you're getting at? If you're not a relative, but you're a guardian or caretaker, is that what you're looking for? You can go in.
Give me an example. Well, these people weren't they?
They were relatives.
Yeah, they were guardians, they were kids, well, not, specifically. Why are they not allowed to intervene? Because if they intervene, when I say they want in, if they intervene, they become either part of this triangle or...
Because it will undermine the weight of the parents?
I'm going to read specifically from the part of the rule. Unless the applicant's interest is adequately represented by existing parties. John, you just not
I was just looking at that. It seems like if let's say the grandparents are really taking on the role of parents, and I'm just thinking of a situation where DCF is just communicating with the biological parents and they're not doing such a good job. The grandparents have a right to be there because they're such a big part of the raising the child.
That's what the grandparents or whoever wants to intervene would normally argue. But why is that argument no good? According to Zelda, there's also a Supreme Court case, I don't know if you guys read it in con law, Smith versus Offer, and I forgot what Offer stood for. It's OFF. Does that ring a bell? Some foster families. No? Okay. Think about it this way.
Because the father is demanding custody for himself.
They have no.
And there's
Yeah,
this third
that's
party.
the parental,
Yep.
right?
And then there's this third party that wants to.
The child, they could be maybe siding with the third party, so the child is going to advance that perhaps. There's the state that's trying to protect the child. Another way to look at it is not so much mentioned in Zelda is when the department approves foster parents, when the department places kids with foster parents, even, foster parents that have been foster parents of a kid for a really long time and love that kid and the kid loves them, all the parents have is a contractual relationship with the state. They have nothing. They don't have the 14th Amendment right that we've all been talking about. As sad as it is in terms of bonding, or the kids love them, they love the kids, they have nothing.
It's just a business transaction.
Exactly. And even when it's a relative, we had a case last year. My associate represented the mother, and the mother was a young, crazy, actually she was mentally ill. Grandmother had the kid from, 2 years old, and the kid was 4. It was a care protection case, and grandmother wanted to intervene as a party. The court relied on Zelda and said, sorry, you can't, I can't let her in. Certainly the department was fine with I know there was a big to-do. I think the department wanted to pull the kid from grandmother for whatever reason. But she lost in terms of being able to intervene. I mean, she won through a back door in terms of, child's counsel and even parents' counsel was, agreeing that the child should remain with grandmother, but grandmother couldn't be a party. So the only parties in care and protection cases are the parents, the family, the state. I mean, the court might hear from foster parents when the case goes to trial. Maybe they call this, and that hardly ever happens, but it's possible. But again, they can't be parties. And that's what Zelda stands for. Okay. I mentioned briefly, when I mentioned 25 before, manual. In fact, today, the court, you sometimes hear the term manual hearings rather than, temporary custody hearings after the case manual. Because besides the issue whether the department should get temporary custody at the initial stage of a case, sometimes, again, you have a parent that says, I've got a sister in the next town. And I'd like the court to consider, in this case, it's not placement, because it was a placement decision. Remember, DCF has that authority. But I'd like the court to consider the sister being the custodian. So the court, under, following manual today, might hold under Section 25 or 24. Okay, not only is returning the child to the parents going to place them in danger of abuse and neglect, and the burden of proof for the department is preponderance, but also considers any evidence related to whether this other person, typically a relative, should be designated the temporary custodian rather than the department. And that's what manual stands for. Yeah.
I was just going to ask, on a practical basis, does that normally happen if you have a child that's been placed in a foster home and there's a third-party relative or something that wants to intervene, and they're of good standing? Would they then remove them from that foster care and place them with the third party? Is that something that would typically happen?
Again, they should if everything's been met. If Corey checks out and it's in the best interest, everything checks out. So it could be an abuse of discretion issue if it's placement, but it could be the parents or the child looking for them to actually get custody temporarily. So it could be either of those issues that come up.
The agency that I worked for, whenever a parent, a relative or cousin, uncle wanted to step in, they're encouraged to come to the have visitation rights,
yes,
come to
yes.
the court proceedings, come to the meetings, our service plan meetings every 6 months. So once they show substantial interest,
yeah,
and
think about it again. It's the department's responsibility. We're talking about families, so whatever the department can do and should do to include families being engaged in a child's life goes to the state's duty, not only to protect the child but also to recognize the rights of the family. All right, so I know I did a lot today, and everybody's eyes getting glazed over.
There's a lot of cases.
There's a lot of cases, yes, and there'll be a lot more cases coming up. So I'll see you next Tuesday. Thank you.
Yeah, so you know more about it.
I don't know.
I'm sure you do.
The 5th?